Welcome to the Probate Nation. Probate is a process to transfer the title or ownership of probate assets to the beneficiary of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate of an estate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets remaining are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. In order to start the probate journey, however, someone needs to be in charge of driving the probate train. The title conferred on that person is typically executor or administrator, and they may be named in a will or volunteer to serve if there is no will. Regardless, that person is not empowered to drive the probate train until they are legally appointed to do so. Today we will learn from an expert the nuts and bolts involved in starting the probate of an estate in the city of Alexandria, which begins with getting appointed to drive the probate train. Joining us is the Chief Deputy Clerk of the Circuit Court of the City of Alexandria, Ben Ortiz. Ben joined the Clerk's Office of the City of Alexandria Circuit Court in August of 2003. During the course of his employment in this office, he has held positions as Courtroom Clerk, Assistant Chief Deputy Clerk, and currently holds the position of Chief Deputy Clerk, Clerk Number 1. As part of his current responsibilities, Ben oversees the Probate Division, and for the past 6 years, Ben has assisted customers with probates of estates and also authorizations of guardians and conservators. Please welcome Ben Ortiz. Ben, welcome, and thanks for joining us today.
Nice to be here.
It's our pleasure to have you. You know, one of the very first considerations in any probate undertaking is to be sure you're in the correct courthouse. This can be especially confusing for an Alexandria estate. Can you explain?
Sure. There are some Alexandria addresses that are actually part of Fairfax County, and our customers, one of the first things that we ask them is, what's the address of the decedent? And we help them determine which jurisdiction is the proper jurisdiction.
Okay, so that's either an address or a death certificate will help you figure that out.
Correct.
Okay. How many probate appointments do you schedule in your office each week?
On average, between 5 and 10 appointments.
Okay, and generally you're the only person that really handles those appointments, as I understand it.
Correct.
In 2016, how many people were qualified either as an executor or an administrator for an Alexandria estate?
Would have to say about 300, a little over 300 qualified people.
And at this point, how many staff support this important function at the circuit court?
I'm the main person, probate clerk, so to say, but I do have some staff that assist me with the processing of all the paperwork.
That's a lot of work.
Correct.
Well, let's take a look. What is probate, and why is it really necessary?
Probate is necessary to be able to administrate an estate, so to say, to retrieve assets that are under a decedent's individual name with no designation of beneficiaries. Financial institutions will not move anything until someone is qualified or a probate has been established.
Okay. And what are probate assets?
Probate assets are assets that don't have any type of designation, such as designated beneficiary or payable on death clause or transfer on death clause. Any asset that does not have those distinctions or designations are considered probate assets.
So a bank account that's in the name of the decedent alone,
correct,
that's a probate asset. And examples of assets that are not probate assets would be those things which actually have a beneficiary designation, like a life insurance policy or a retirement account.
Correct.
Or it might be, an account that actually was held jointly with somebody.
Correct.
And so it passed to the survivor. Now, what's the difference between being between a beneficiary and an heir at law?
Beneficiary is someone that's named in the will to receive something from the estate.
Okay.
An heir in law necessarily doesn't have to receive something. Heir law is the next of kin of the decedent, and those are the ones that we are more focused on when there is no will.
Okay, the heirs of law. Now, can anybody, act on behalf of the estate?
Only a qualified representative, legally qualified representative, can act on behalf of the estate, someone who has gone through the probate process and the qualification process through the courts.
Okay. Now, and that's what you mean by getting qualified or qualification. They go through the formal steps of actually officially being designated.
Correct.
Let's talk a little bit about the qualification process. How do we begin that process?
First off, it's a call to our office. I know it sounds simple enough, but it really is. We try to ask certain questions to make sure, of course, what we mentioned earlier about the correct jurisdiction, if there's a will, the status of the decedent, whether they were married, divorced, widowed, so on and so forth.
Okay. Now, how soon, if I called in today, how soon can we get an appointment?
We try to schedule appointments within the week of calling. Basically, we have been able to accommodate people with their schedules and their needs, of course.
And what should I bring to my appointment?
Most importantly is a death certificate. Without a death certificate, we have no proof of passing, and that's something that we always have to have. The original will, if the decedent left one, and basic information about the estate, the next of kin, approximate value of the estate assets, addresses of any real estate that was left behind, things of that nature.
Okay. Now, I know that you do have some information on the website about this process, and we posted that website on the screen. And that is a resource to identify some of these things that people need to bring to the appointment. Do you want people to complete any documents in advance?
There are some state forms that would be helpful. It's not required. Most of this information we would have to enter anyway into our computer systems, but they are beneficial to bring along just because the information is right there and easier to enter into our systems. It's
kind of a way to remind people what they need to collect by way of information.
Correct.
Well, let's talk about bonding of the executor. This can be a game changer.
Yes, sir.
So let's talk about that. It's my understanding, that in some cases, it's really necessary to know whether the executor can be bonded, if they in fact must be bonded, or if there is an intestacy, then they have to be bonded. All personal representatives must be bonded. Can you explain why?
Sure. The authority that the court is giving to these personal representatives is to go out there and retrieve any and all assets under the estate. So we do have to protect the estate, their heirs, the beneficiaries, and even the creditors. So that's where this bond comes into play. The bond holds them liable to be able to comply with their duties as the personal representatives of the estate.
Now, some bonds can be without surety. What does that mean?
Surety is hiring a bonding company to actually post the bond or the corporate surety on the bond for this qualification. 9 times out of 10, I'd say that wills always waive that surety. Our office, the court, is the one that actually determines whether we can follow that waiver or not. Most times we can, sometimes we cannot. In intestacy, when there is no will, we almost certainly always have to have surety on the bond.
And surety on the bond is really a way in which to basically insure against some problem occurring in the course of the administration of the estate.
Correct.
So we want to make sure the person, if they have to get surety on their bond, make sure they can qualify. So getting a bond is not necessarily that simple. So is it important for them to go ahead and advance and make that bonding application to make sure they're going to be able to be bonded?
Yes, sir. Without that approval, we cannot move forward. When it's a bond without surety, we're good to go. But if it's with surety, they do have to do that ahead of time. Without that approval, again, we wouldn't be able to move forward.
So that they do want to get that taken care of. I know we have previously done a show about bonding the executor, and that can be a challenging process. Folks who are going to need to get bonded might want to take a look at that show and some of the comments from the bonding agents about things to be concerned about. There is a bond without surety, okay? So that's a personal bond. That doesn't necessarily mean that you're not bonded, which means that you're personally liable at that point and there's no corporate surety. Do you see a lot of those bonds being issued without surety?
Yes, most times when there is a will, they include the decedent, one preparing the will, included that waiver. And you're right, they are still held liable, but they don't have that extra requirement of having to go through a bonding company to post a surety.
Okay. Well, I think the big thing to take away from here is that you want to be careful. I know that's one of the first things you talk about is, do you need to be bonded or not? So
Correct.
we want to get that squared away. So now we're going to go ahead and talk about the qualification appointment. We've called your office. We have a date to come in and visit with you. Where's your office located?
The address is 520 King Street. The suite number is 307.
Okay.
Alexandria, Virginia. Zip code's 22314. We're in the heart of Old Town, main courthouse. When a customer comes in with their appointment already set, they arrive at our suite, which has a front counter where our regular staff is situated, and they can walk them back to my office, or I'll go out and greet them and bring them into my office myself.
That's great. What kind of questions might be asked during a probate appointment?
The primary questions are, did you bring the death certificate? Again, without that, we can't move forward. Reviewing the will, make sure it's an original. Nowadays, with technology, some copies actually look like originals,
Sure.
so that's something that we review right off the bat. And the supporting information documentation, the list of heirs, information on the assets, addresses on real estate, and what have you.
Okay. So then what proceeds from there? The appointment unfolds, and assuming you begin to, you ask those questions and things all start to fall into order. There's something called a probate tax.
Correct.
What is that?
Probate tax is it's a requirement when we're establishing an estate, and it's a one-time tax fee that's related to the value of the estate. Without collecting that probate tax, we would not be able to complete the qualification process.
Okay, and that's not an estate tax. That's just it's not an estate tax like a federal estate tax. It's
Correct.
different.
Correct.
Now, if there's a bond required, will the bonding agent be there at that time typically, or?
Yes, typically they will be there. Sometimes these bonding agents, they're going from court to court. We try not to hold up our customers because of the agent not being there, but we always have a good communication with the bonding agencies that the customers use.
So we need to sign that. We need them to sign off on the bond
Yes,
before
sir.
you actually can issue the certificate.
Yes, sir.
Okay. What are some of the common issues that you run into during an appointment that actually delay or prevent qualification? I know you've mentioned a couple of issues.
Right. Again, the death certificate, without that proof, we can't move forward. If they bring what they believe is an original will, but turns out to be a photocopy, can't move forward. Sometimes wills name more than one person to be executors of the estate,
yes, that's true.
and over the telephone conversation that might not be mentioned, and then when they come and present the will, then, oh, where's the other person? So that does delay the process as well.
Okay. Now, can an out-of-state resident qualify as a personal representative for a Virginia estate?
If they meet the requirements, and most importantly would be the surety on the bond, yes, they can.
So even if they've waived bond in a will, if they're out of state, we're going to have to get them bonded.
Yes, by statute, we do have to require that.
Yes. So we get to the conclusion of the probate qualification meeting with you. What does the applicant receive to show that they're actually now duly? I mean, I assume that they get sworn in.
Correct.
And what do they get to show they're now in charge?
There's a document titled or called a Certificate of Qualification. Now, different jurisdictions may call it something else, letters of testamentary or letters of authority. That's a document that they leave from the appointment with, and that's what they present to whomever is holding assets under the estate name or the decedent's name. And they have court seals on them, and that's what these different offices and agencies, financial institutions will be looking for.
Okay. Now, once a person gets qualified, they've received a certificate of qualification, do they have any obligation to give notice to the heirs?
They do, by statute. The heirs and the beneficiaries, if there is a will.
And do they need to let you know that they've done that?
In a way, yes. They file an Affidavit of Notice that lists every person that they've sent the notification to what address, and when they actually send it out or delivered. Most times, they're siblings or close family members, so they can hand deliver it as well.
Okay. I know we were talking in preparing this show that you really don't track whether or not they actually file that back, but we had occasion to talk to Gary Lonergan, the Alexandria Commissioner of Accounts, and he shared with us that he in fact does verify that Affidavit of Notice is filed in the course of his review of filings in his office. And here's what he had to say about that.
Yes, we are tied in electronically to the fiduciary files in Mr. Ortiz's office. So when an individual qualifies, they must, within 30 days, send notice to anyone with an interest in the estate, whether you take under the will or you're an heir at law. They have 4 months to file that affidavit of notice with Mr. Ortiz. I cannot approve an inventory unless that affidavit of notice has been filed by the fiduciary. It's by statute. It's very cut and dried. And so that's a stop point.
Okay.
And so the inventory could be perfect in every other respect, but if we see from the fiduciary files that they haven't filed the affidavit of notice with Mr. Ortiz, which costs $16 to file with him, then we've got to blow the whistle, and we do, and tell the fiduciary, you got to file this.
Well, that's very interesting. I know that you and Mr. Lonergan work very closely together, both with your offices, to make sure these estates get handled properly.
Correct.
And, Mr. Lonergan's comments certainly show that. Is there any other reason why somebody would need to return to the probate office after they've been qualified?
Most times, no. The most common factor that would make someone return is to receive more certificates of qualification. Sometimes these certificates are retrieved or held by the asset holder, and if the executor runs out of them, they can always come back and get more. Another occasion would be any modifications to the bond. That's a rarity.
Okay. Now, do you give anything out to the applicant once they've been sworn in, they've received the certificate of qualification, and now they're in charge, and they go, well, now what do I do?
Right. We hand out an information package. I most times tell them this is your instruction manual. It has steps.
Is that this voluminous
Correct.
instruction to executor and administrators?
Correct.
Now, we showed on screen the first page of what is it's a heavy set of documents that, with various forms and, of course, examples of how you do certain things, both with the Commissioner's office, but you hand this out to them.
Correct.
Now, how do you verify that they actually receive that?
The information package?
The information package.
There's an acknowledgement sheet that we have them sign.
Oh, so they have to say that they've received
Correct,
this.
correct. That way, when they call Mr. Lonergan and say, well, I didn't know I had to do that, they can check the file and say, well, you signed that you received the signed the acknowledgement sheet saying you received the package.
That's very wise.
And that's where all the steps are, all the forms and such.
That's a very good idea. Let's talk about, this sounds very, very complicated. A lot of moving parts, different things to be done, both to get started and then as we go along. Should someone get a lawyer to help them get qualified?
I agree with you. It's not the easiest thing to do. Some people may think this is very simple, I'll do it on my own. We always advise people, if it looks complicated, if there's too much information, if there are too many assets, then definitely get some legal counsel to help you out. Okay,
that's a good idea. And again, this particular instruction manual that you guys have handed out is an extraordinarily helpful roadmap as what they've got to do and when.
It is.
I noticed there's some tips in there as well that I know that Mr. Lonergan has compiled.
Correct.
To give people ideas about things they should do.
Correct.
So, very valuable tool. Well, any final thoughts you want to share with us about the probate process, how to get qualified, common problems you see that occur that you want to share with the viewers?
Well, I would just say that call our office. I mean, that's the best thing to do. Many times people go online and search this, search that, and we have to correct some information that they may have found online. But most times we can answer their questions and try to guide them to the correct jurisdiction, correct process, so on and so forth. So a phone call away, and we'll help you out as best we can. That's fantastic. Well, Ben, I want to thank you for taking the time to share all this valuable information with us today, and I also want to extend our appreciation to Ed Simonian, Clerk of the Circuit Court of the City of Alexandria, for his support of this program as well. Mr. Simonian, yourself, all the folks who work at the probate office there do a great job, serving the citizens of the City of Alexandria, and of course supporting the Circuit Court of the City of Alexandria. So thanks for that great public service. Please keep up the good work. You're very welcome. The citizens are also welcome as well. Thank you so much. Without a doubt, probate can be complicated and confusing, but Alexandria Clerk of Circuit Court Ed Simonian, Chief Deputy Clerk Ben Ortiz, and the many other folks who support the probate office in the Alexandria Circuit Court have done a wonderful job of making the qualification process simpler and user-friendly for those who need to probate an estate in the City of Alexandria. Beginning when you call to make a probate qualification appointment and Ben confirms some initial facts, advises whether you need to arrange for surety bond and what documents you should bring to your appointment, to when you walk through the front door of the City of Alexandria Courthouse and head upstairs to the probate office on the 3rd floor for your scheduled appointment,
to when you are greeted by Ben Ortiz and are escorted back to his office to complete the necessary paperwork, to when you raise your right hand, are sworn in and given your official certificate of qualification, to when you head out the courthouse and you're ready to get started on your probate journey. Each step has been organized to make this a pleasant experience. And be sure to check carefully all the useful guides and forms and checklists they have assembled in the package of instructions for executors and administrators that you receive at the time you qualify, as these will serve you well and help you navigate the probate you are now going to embark upon. This brings us to the conclusion of our show today. Getting qualified in the City of Alexandria Probate Office is just the beginning of your probate journey. So as you take a seat and the probate train pulls out of the station in downtown Alexandria, take a moment to toot the train horn and congratulate yourself on a job well done. The next stop for the Alexandria probate train will be a visit with Gary Lonergan, the Commissioner of Accounts for the City of Alexandria. On behalf of the Probate Nation, thank you for visiting with us today.